Great. Thank you again, everyone, for joining today on this topic that a couple of months ago would not have expected to find myself talking about. For those of you who haven't met me, don't know who I am, my name is Kreamer. I'm a barrister at Radcliffe Chambers. Over the last few months, I have all of a sudden found myself instructed on Part A1 moratorium after Part A1 moratorium. And so 6 years after SEGA introduced this mechanism, I think it's quietly moved and slowly moved from a tool that everyone viewed as a bit of a novelty and something that we were just not seeing in the market and not using, to something that we actually might expect our clients to ask us about, and something from my perspective that I'm being briefed on at the moment on a weekly basis. So this session is a bit of an introduction, because much as they are 6 years old, I know that lots of us won't have come across them before. What it can do, where it can trip you up, and what the last few years, I suppose, but for me, few months of practical application of these have taught us. A couple of questions have been sent to us in advance, so I will drop those in, sprinkle those in as I go through. If you have any, I suspect we're not going to have time. It's only a short session this morning to go through questions at the end. But if you have any, you know where to find me. You can call my excellent clerks anytime, and my email address will appear somewhere on one of these slides. And hopefully lots of you have it already. So I'm going to start off asking why all of a sudden we're talking about this now. I'll go through a little bit of the framework, because as I say, I know that these are not entirely familiar to everybody on the call. The strategic approach in my experience, and in particular my recent experience to these, the role of the monitor, which is a slightly unusual role and position, how they work in terms of extensions and exits. And this is one of when I'm talking in particular to IPs and those thinking about whether they want to fill that monitor role, they're particularly keen to understand the scope of these in terms of length, but also how the company gets out of them at the end. And then a little bit about the pitfalls, the places you can fall down on these, and some practical lessons. So why now? Why is this worth an hour of your time 6 years in? These are the stats as they were about 5 days ago when I pulled these slides together. And I've said it's a slow build, not a boom. The latest stats came out on insolvencies. The Insolvency Services latest figures came out a couple of days ago, and there were 8 in June. I think I did 8 in June. So they are starting to creep up, and you sort of see that increase. Even November to May, there were only 3 more, and then we've had 8 last month. So a bit of an indicator that they're starting to increase. I think that the figure for Part 26A by that juncture was 60. So I think there had been 2 of those in June. So we are seeing relatively equivalent. There are more Part A1 moratoria than RPs, but they are so much less widely known. I suspect that's in large part because lots of these, it doesn't tell you the split between those, and I'll come on to how this works, but the split between those that are done by way of the out-of-court process, by way of the filing of documents. I suspect it's the overwhelming majority, and those that are done by way of court application. So that may be why we hear more about the RPs than we do about the moratoria, because those cases are largely out of court and sort of almost by their nature quietly done in the background. But certainly barely a handful right at the start, 4 in the first year of operation. And then you're seeing this slow, steady build through the chart. Again, some of the stats that I've been able to glean from the Insolvency Services post-implementation review. Now, just to flag per the very bottom of this slide, that review was June 2023. So we're now 3 years on. And the figures, therefore, in relation to these stats are out of date and from a very small sample size. I think we go back by June, we'd only seen about 40 of these. So double now. But at that juncture, more than half were reported to have resulted in the rescue of the company as a going concern. Over a quarter resulted in a CVA being agreed once the moratorium was in place. But because of the nature of these, and as I say, I'll come on to why lots of them aren't dealt with in the authorities, there aren't many reported decisions. So in 2022, we had a case called Corbyn and King and Diamond. That was the first judicial guidance on monitors' decision-making, standard of review. Then we had Regrove Independent School in 2023, which is a very useful decision. But that was the first one we had where an application had been made to court where a winding up petition was already on foot. And then a couple of weeks ago, we had Recross Transport. It's a slightly more niche decision in relation to the effect of paragraph 64 capital A, which was inserted at post-SEGA in relation to the treatment of the monitor's fees in a subsequent administration. And I'll come on to that, but that's another decision. So unusual are these that I think the judgment refers to it as a Part 1A moratorium and not a Part A1 moratorium. So there is a real lack of familiarity judicially as well as between those of us who work in this area. So why is there that relatively low uptake? There are IPs on this call, some of whom will identify with this, I think. There is a hesitancy, I think, in large part because of reputational risk. I'll come on to why that would be the case in these, but as those of you who are a little familiar with them will know, they are, I think, but because the monitor has to speak to the likelihood of the company being rescued as a going concern, and because of the level of reliance the court places on that when making an order or deciding whether or not to make an order on these, I think there is a real sense that there's a reputational risk. You don't want to put your name to something that when it comes before the court again for an extension, the court thinks, how on earth could anyone ever have certified that this company was likely to be rescued as a going concern? I think there is also director hesitancy because of notification supervision requirements. It is a debtor in possession tool, but it's one which involves a high level of supervision from an IP. You also have to put it on Companies House and on all of your invoices and on your website. So for those who just want to avoid advertisement of a petition, it's not necessarily the most attractive alternative. Likelihood is a pretty high threshold. You have to certify that the company is likely to be rescued as a going concern. Pretty much you need some measure of support from your secured lender, for reasons I'll come on to. And also I think in the market there remains a higher level of comfort with what I call the more traditional routes, which I think now even include RPs for more mid-market companies. We're now seeing them that mid-market level, although part of the requirement is that you don't have any complex capital market debt or similar structure, and at SME level as well. It's companies, in my experience, with short-term liquidity issues, but a near-term and viable refinancing plan. And where I'm seeing it, and well, one of the areas I'm seeing it are, all of you on this call, I think, will know that HMRC has become ever more aggressive in recent years in terms of its position on adjournments of winding up petitions. So the ones by their nature that come across my desk are where a winding up petition has already been presented, and so the company has to make an application for a moratorium to court. We will all know the feeling of a client asking, will HMRC agree to another adjournment, or will the court give me another adjournment of the petition? I think you can still fairly safely advise that at a first hearing with some plan referenced, you will get 6, 8, 10, 12 weeks by way of adjournment, depending on what sort of alternative you're planning to a winding up order. But for subsequent adjournments, whereas when I started out, I think you could, again, have advised that fairly safely that you're likely to get another adjournment. Nowadays, I think that's much less likely. I'm also seeing them in cases largely where there is some, I've put sizable, that might be too strong a term, but some kind of fighting fund to get a moratorium off the ground. Because once you're in the position of being post-petition, you need some money for your lawyers, you need some money for your monitors, because there's weekly supervision. So for the monitors, there is that ongoing cost. And then there are the costs of subsequent court hearings for extensions. So the framework, this is a relatively fast recap. I know that most of you will know the basics, but Part A1 moratorium is a freestanding debtor in possession process. was meant to be akin to Chapter 11 in the US. I'm not sure it's quite met that brief, but what it is described as, and what Grove School calls it, is a breathing space, providing a breathing space from creditor enforcement while the company explores its options. The reason it can exist as breathing space and as debtor in possession is that it is supervised by an independent monitor who must be a licensed insolvency practitioner. So it should be viewed as, and it is, a bridge to a standalone recovery, to a CVA, to a scheme, to an RP, or indeed another insolvency process in a more orderly fashion than might be the case if you were facing an abrupt cliff edge on a compulsory liquidation with a winding up petition that you otherwise don't have much basis for seeking an adjournment of. It isn't a separate insolvency procedure. It's not a long-lasting, it's not the way out, it's a bridge to the way out. It's not a discharge or compromise of any of your debts. It's not a substitute for a credible rescue plan. And it is not protection from every creditor, which I'll come on to. And as I am starting to see on court applications, it is not a free pass. And I set that up as a bit of an intro into regrowth schools, which tells you a little bit more about what the court will, the test the court will apply. But there is one pitfall which I will come on to later in terms of quality of monitor's report, and my recent experience emphasises that the court will not simply wave these through. And indeed, I'm starting to see HMRC will not simply wave them through either. A company qualifies if it is or is likely to become unable to pay its debts. The directors have to certify and attest to that. The proposed monitor, and this seems to me in relation to moratorium cases to be fundamental, the proposed monitor confirms that rescue as a going concern is likely. I'll come on to the strategy of that in a moment. And there are provisions about it not already being subject to certain other insolvency proceedings. It's excluded. There are various exclusions. Check these very closely if you're looking at if you're being asked about these by clients. Banks, obviously, insurers, e-money payment institutions, other regulated financial bodies are excluded from the scope of Part A1. As I mentioned or referred to earlier, it can't be party to capital arrangements with a debt of 10 million or more. So that's where you're seeing that sort of SME mid-market level, because it is meant to be relatively light touch, obviously with the supervision, and that can be not so light touch, depending on the circumstances of the company. But that shows you the sort of intention behind this part of the Insolvency Act added in by SEGA. And also can't be an overseas company on the filing of documents at court by a director. It can be if it's by a court application. They've alluded to this several times already. There are two routes into a moratorium. The first is through Part A, section, that should say A3, which is an out-of-court appointment. That is available where there's no winding up petition and where all of the other eligibility criteria that I've mentioned already have been met. They take effect automatically on filing when directors file prescribed documents at court. And just to pause there, I had one of these where we filed documents at court for an extension, and the court sealed them and listed them for a hearing. So unfamiliar are they with what these are? So just something to be alive to, that because they have seen so few of these and the court staff are so unfamiliar with them, we just had to write to the court to say, please vacate this hearing, we don't need it. This takes effect automatically upon filing. But you may get those sorts of quirks in this process because the court is not familiar. That's the cheap, easy, low-cost route, makes these really attractive. And as I'll come on to, you get 20 business days at that juncture. That is not available if a petition has been presented. And so then Section 8.4 comes into play. Court application is needed if you're subject to a petition or if it's an overseas company, and you've got to have a hearing. The court has got a discretion, and there is a materially higher evidential bar. There's a pretty low evidential bar on a Section A3 filing at court. You do need your monitor to have certified the company is likely to be rescued as a going concern, and you consent to act as the monitor. But you need a lot more on a court application. I've just set out here the documents. They're called the Section A6 documents that you've got to file at court. A notice from the directors that they wish to obtain a moratorium, a statement from them that the company is or is likely to become unable to pay its debts, I tend to prefer to file those as a document, as a composite document. I've seen it done with a separate notice and separate statement in the statements, but from counsel's perspective, when you're taking the judge through the sort of tick box exercise of confirming that all of the technical requirements have been complied with, it's helpful to have all of that in one place so the judge can sort of tick that off his or her list. Then, crucially, you need a statement from the proposed monitor that he or she is a qualified person and consents to act, and then the critical point that they are eligible and it is likely that a moratorium for the company will result in the rescue of the company as a going concern, and the usual joint and several statement. In the case of two or more monitors, I have only seen two, and I have seen one. I haven't seen three, but I don't know any reason that wouldn't be possible. So the life cycle of a moratorium, if you file your documents at court pre-petition, or if you get a court order, the moratorium then takes effect immediately. Slightly oddly, the initial period, as it's termed in the legislation, starts from the following business day. You get 20 business days starting with that date. So there is a bit of maths. No one actually tells you the dates, and they are business days. So the ones I did in May were really awkward because you've got all the bank holidays, but they are 20 business days. So you can't neatly count down on a calculator week by week always. You obviously can sometimes if there are no bank holidays. So you get 20 business days to start with. Then, pursuant to section A10, the director or directors can extend a loan without the need for creditor consent for a further 20 business days. There's then, as I've put this as a linear timeline, it's not quite right because there's a slight divergence. From the outset, with the consent of your pre-moratorium creditors, you can extend by up to 12 months. Now, I sort of say it as a bit of an aside, I've never seen that achieved. Almost always the reason your clients will be pressing for this is that the revenue is on at them, or there are other aggressive creditors, but as we know, it is very commonly the revenue. I think it's fairly rare you're going to get that consent. I also think if it's sort of trading entity, often it's so cumbersome to get creditor consent for anything that it's just not going to work. And also you're having to be quite agile with these applications. There will be companies where it will apply, that there will be the right company. I have got one at the moment where the revenue is the only non-connected creditor. It's part of an enormous group. The reason the director wants to keep it alive is that loads of tax losses sit within the company, and there's just a liquidity issue with the group, and they're in the course of a wide scale and wide-ranging refinancing. But HMRC have been extremely tolerant in this one, but by the time we got the Part A1 moratorium, the winding up petition had been on foot for almost a year. So I don't think HMRC would have consented, but if we'd done moratorium from the outset, they might have. So there will be relatively unusual sets of circumstances where that will arise. Then beyond the first extension, i.e. the initial period, then the first director-led extension without the consent of creditors, or beyond the 12-month period, you get a court extension only, and that's an application pursuant to section A13. I've put a big box in bold at the bottom. At every stage of extending these moratoria, you have got to, the monitor has got to confirm at that point that rescue as a going concern remains likely. And indeed, that's an ongoing process, which I'll come on to, but the monitor has to be satisfied at every juncture that the company is capable of rescue as a going concern, or it must, or the monitor must, they must bring the moratorium to an end. What do they actually do? What protection do you actually get from them? You get a payment holiday to most pre-moratorium unsecured debts. There's some quite technical provisions about what is and isn't included. I'd recommend having a look at the legislation if you're thinking about these in that level of detail. And likewise, I would be very happy to have a chat about any where you think this might work. But it applies for the duration of the moratorium. So you can see, again, it's a little bit like when you're saying to clients, you can have a 12-week adjournment, you can ask for a 12-week adjournment of a winding up petition. That gives you that breathing space. That's how clients often view that adjournment. And obviously, there's nothing else that can be done by the revenue or by whoever the petitioner is at that juncture. I think these are a little bit like that in that way. The debts still sit there, as I said at the outset. There's no compromise or discharge of those debts, but there is a payment holiday, and you are not allowed to make payment of those debts during the continuation of the moratorium. Financial debts, crucially, are not included. I've listed some of the examples, but you all know what financial debts are. Nor are wages, goods and services supplied during the moratorium, things like rent for the period of the moratorium, and generally for what are called under the legislation moratorium debts, which are those incurred during it, and they've got to be paid in full as they fall due. And indeed, that is one of the criteria for extensions. One case where I have seen HMRC object to an extension of an extant moratorium on a court application, they objected on the basis that certain debts hadn't been paid during the moratorium. It's a slightly technical point, and I won't make it in too much detail now, but we had a very interesting conversation or discussion with the court about it at the hearing. HMRC did its thing of putting in a witness statement and then not turning up, which I think annoyed the judge, and so the judge didn't give very much credence to their position. What HMRC's position seemed to be in that evidence was, so for the PAYE period that concluded prior to the entry into the moratorium, so a pre-moratorium debt, it had fallen due, i.e. the date for payment under HMRC's rules was during the moratorium. And we said successfully, and we had evidence from our monitor to support our interpretation, that is a pre-moratorium debt because it related to a period for liability before the moratorium, but just a cautionary tale that HMRC is starting to try to assert itself in relation to moratorium cases. Another example, just this week, last week, we were applying for an extension to a moratorium, and HMRC told us about 20 minutes before we were going into court that they were going to oppose and wanted time to put in evidence. I should just say, going back to this life cycle, the operation of the legislation is such that if you are applying for an extension, once you have made your application, your moratorium is automatically extended until the point at which the court disposes of it. So on that one, where we'd applied in time, got to apply in time, otherwise it comes to an end. As long as you've applied in time, the judge then said, okay, I'm going to give HMRC a month to put in their evidence. I'm going to give you a month to put yours in, and we're going to come back in September. The moratorium is therefore in effect extended until September because the application has not been disposed of. And I believe that's sections 813, 6 and 7. So that's something to be aware of. All right, that's the mechanics. So how do we turn that into a working application? What are some of the strategy considerations? I was having a think about this. These were the 4 things I came up with as the real crucial. If you remember anything in terms of strategy, remember these. Firstly, it's obvious, but make sure you know whether you're in the sphere of filing at court or making an application. That will have quite a material bearing on how long it's going to take you to pull this together, the likelihood and what you can advise your client about prospects of getting this. And also from the perspective of the monitors, for the IPs on the call, the work that's required in terms of either certifying for your own satisfaction that the company is capable of rescue as going concern, or to the satisfaction of the court in preparing a report. And I'll come on to the monitor's role in a few moments. Test the viability of the moratorium. It's so tempting. And I have advised on one of these where there might be a sale in prospect, or there might be an investment in prospect, or there might be a refinancing in prospect, to think, if we could just get a bit more time, we can achieve this. I would suggest that it is wishful thinking doesn't have any real place in this scheme. And I think increasingly monitors will have more stringent requirements as they become a bit more familiar with these and with the applications. And as the court becomes a bit more familiar with the sort of case where it will expect a rescue to be possible, or indeed to be likely, as it's going to have to find in order to impose a moratorium. So testing viability at an early stage is really important. You need to be, I think, underway with a process of refinancing, or have a really good reason to think that it's going to be capable. So it's going to be possible. So I think, whereas on a winding up petition, you might be able to say to the court, 12 weeks, we've got a term sheet from a lender, or we're thinking about borrowing more money. That's probably enough to get you 12 weeks, but it won't be enough to get you an initial period of a moratorium. Relatedly, I think line up the proposed monitor very early and use somebody who has some experience. There's a bit of a catch. It's a bit tricky because there will always need to be a first one. And I have seen some monitors do these as loss leader is probably the wrong term, but working much harder to understand how these work. It's like everything you do. As soon as you have a bit of familiarity, the next one is easier, and the next one after that easier still. But have a think about who you're going to use. Have a frank conversation with them about their level of familiarity with these. Not least because, per the fourth bullet there, they and we need to prepare for real scrutiny of these by the court. And I had my first ever refused application. Judge Prentice asked me whether I was aware of any others that had been refused, and I'm not. But the application was dismissed on the basis that the monitor hadn't prepared a report. So this came to me very urgently. It had been issued and listed very urgently, and really it wasn't anyone's fault other than probably the directors, who are in all manner of difficulty in relation to their filing requirements more generally. But I think they had come to their monitor late in the piece. They had seen the moratorium as a way of guaranteeing a bit more time on a petition, which I think otherwise probably would have resulted in a winding up order, or certainly they thought it would. And so the monitor had sort of scrambled to be able to certify and had doubtless done the work behind the scenes, but there was no report. And so where the judge already thought it was a bit dubious as to whether this was possible, and then they didn't have any detail from the proposed monitors about how they had reached the conclusion and satisfied themselves that this company was capable of rescue as a going concern. The answer was a no, and our application was dismissed. Incidentally, you can apply again. So, and that was what the judge did. I think if that hadn't been possible, he'd have adjourned to give us time to put more evidence in. But as it was, I think he wanted to send a bit of a message and dismissed. Case spotlights is my heading on my notes. There are only a couple, or a handful, so there's not very much to say about the case law, but Regrove Independent School is a very useful one. This was an independent school with 200 pupils, 50 staff, a revenue petition for pre-pandemic tax arrears. This was a 2023 decision of Judge Greenwood. There was a £2 million balance sheet surplus in this case, a £4.25 million freehold interest in property, and the only secured creditor crucially supported the application. So quite favourable facts, but a good one for some exploration of some of the principles. I've put out a couple of the quotes that I've taken from all the skeleton arguments I do on these cases, but achieve a better result for the company's creditors as a whole than would be the case if the company's wound up without first being in a moratorium. And the court's got a discretion is what's clear from that authority. As a matter of strict language, the judge says it seems to entail or invite a comparison between the sorts of uncertain scenarios that we're very used to dealing with as those who operate in the insolvency sphere. You think about estimated outcome statements. I think every monitor's report should have in it an estimated outcome statement that sets out the outcome in a moratorium without the outcome in a moratorium and then the outcome in a liquidation administration, probably, without first having been in a moratorium. And it's a bit like you see on RPs, the sort of most likely alternative. I think you should think about the most likely alternative, and I think most monitors will be doing that when ascertaining whether the company is going to meet that test. And just the final point I think to note on that slide is that the judge held that was on the balance of probabilities, not a real prospect or possibility. And that's just a further summary of what the Act requires in Judge Greenwood's view. I had another one of these before him where I'd cited this decision because it's the only one there is in my skeleton. And he said very honestly that he did remember having written it, but hadn't had cause to read it since. And that was a few weeks ago. So again, just a further example of the infrequent nature of these before the judges until now. So the monitor, those of you, the IPs and the IP team members on the call, the thing that you will be most interested in, you will all want to understand whether these are something that you should be adding or could be adding to your portfolio of options. And I absolutely think that you can. For 6 years, we've thought, yeah, but where are these going to be used in practice? And I have now seen a really wide range from, as I say, kind of little minnows in big groups. Another one where they were listing on the NASDAQ in the US, and so they needed time to complete that process. Another one where there was a dispute under Eco4, one of the energy schemes, and they were trying to get one of the energy companies to come to the table because its retention policy was such that it was holding millions of pounds of their money, which had caused their cash flow to deteriorate very, very rapidly. Another one where they were in the course of refinancing, but MFS, the administration of MFS, had caused material delays to that MFS was the outgoing lender, and so they had to get in contact with the administrators. There was no way another adjournment of the petition was going to be granted. So quite a wide range of circumstances where you might want to recommend these. Some sort of a summary of what their role is, in my view, in accordance with the legislation. So they've got to be a licensed IP. They are appointed by the directors, not the creditors, and there is an independence by design, in as much as their overview is absolutely fundamental to the operation of these moratorium cases. The gating statement, this is the confirmation that the company is likely to be rescued. It's not reasonably likely. It's a pretty firm statement. And this is what this comes back to the statement or the suggestion I made earlier, that you need to really stress test viability at an early stage, because if the monitor can't get comfortable, then it doesn't go anywhere. There's then, as I say, the ongoing oversight. So they are monitoring the company's affairs, they're monitoring cash flow. They consent to specified transactions under the legislation, which disposes outside the ordinary course, to granting security to certain payments that the legislation identifies. So there's quite a lot of hands-on involvement on the part of the monitor. So for the IPs in the room, you need to be sure that you're comfortable with that you can work with these directors, and that they can pay you to do it. They're also really attractive, I think, to IPs because of that. It's not a one-off piece of work, it's an ongoing piece of work. And because of the nature of them, because of the nature of the kinds of companies and directors that I am seeing using these, they are often the sorts of extremely optimistic directors who will say to you, but if we just had another week or another month or another 6 weeks, we would get this over the line. And then 6 months later, you're there applying for yet another extension because it hasn't got over the line yet. And all the while, the monitor is working and supervising and overseeing. So ongoing oversight is crucial. And as I've said already, it's a continuous test. And Section 835 tells you as the monitor that if at any point you are unable to satisfy yourself that the company is likely to be rescued as a going concern, then you are required to terminate. That brings me on to when you are required to terminate. That's the first point under Section 838. Secondly, when the objective has been achieved. So typically that's you've paid off the petitioner, or you've paid off whatever debtors would have petitioned if you hadn't got yourself a moratorium. If you can't perform your functions for lack of information, I think there will be these cases where directors just lose enthusiasm, realise that this isn't going to work, and it falls off a cliff edge again, and the monitor can't perform their functions, and you retain a very substantial and significant level of control in that way. Moratorium debts or pre-moratorium debts without a payment holiday go unpaid. My experience is there's a bit of flexibility in this. I've seen a couple where they haven't paid HMRC in terms of their ongoing PAYE. As long as they rectify it within a short period, I'm finding that monitors are happy not to bring it to an immediate close, but to give the directors time. I think that's sensible. I think that the very fact that the company needs a moratorium suggests that it's in some difficulty and that ongoing cash flow is going to be a pressure point. So I think that's reasonable, and I don't think the court would ever criticise that. But on the extensions that I've done where we have missed payments, I think the right approach is for the monitors to identify that in their updating report, confirming to the court, or their witness statement, confirming to the court that they're happy to continue to support. And the ones where I have seen it viewed best by the court is where directors confront in their evidence in support of an application to extend the fact that they haven't, or they've missed payments, haven't complied with the statutory framework, an explanation for the same, and confirmation that the missed payment has been made. I think that's probably fundamental, and that further payments can be met. And that's a question I've been asked by judges where cash flow continues to be difficult, where you're asking, say, for 3 months of a 3-month extension, and a judge will say, well, but they've got 3 more PAYE periods now. They've had 1 and missed it. How can we have any confidence? So I think the evidence needs to address any of those kinds of issues. In terms of not sort of compulsory termination, but best practice, reassessing regularly. It will depend on the company and its nature, but perhaps daily. And perhaps those conversations you're having with directors daily about what their cash flow looks like and what their payments out look like and what their income looks like. I think it's really important to document the basis for continuing to support at this juncture, because they're so unusual and they're such an unknown quantity. We're not seeing creditor challenges really. Corbyn King was one, and that was a decision from 2022, which I will come on to. But there will be more challenges. As I say, that I have done one where HMRC has actively challenged. They weren't successful because they didn't bother to show up, but they will start to do so. And I think my one from last week, where they asked for time to put in evidence and to arrange representation, tells you that conversations are happening in HMRC about how they approach these situations. And request everything you need and challenge information that doesn't add up, but as the monitor, do document that. Make sure you're being clear, because if at any stage there are challenges, and I think there will be challenges where they say the monitor should have terminated this much earlier, you will want to have a documentary basis to support, just file notes to support the questions you've asked and the reason that you are not terminating, the reason you remain of the view that the company is likely to be rescued as a going concern. This was one of those cases back in 2022, so early in the piece. This was Corbyn and King Group, which owns the Wolsey and the Delaunay and various others. A secured lender demanded repayment. The monitors chose not to terminate in response, and an application was made to challenge that decision. Some encouraging views from the court about this. The monitor's judgment stands unless reached in bad faith. So it's a pretty high threshold, or where it's so perverse that no reasonable monitor could have reached it. Able to pay, ability to pay, turns on an immediate prospect of third-party funds or realisable assets, but that's a commercial judgment, the court says. So if your director is saying to you, look, here are the heads of terms for a refinancing on this element of our business or this asset, we're being told that this transaction will complete in the next week. I think that would be a very reasonable basis for considering that the company has or will shortly have funds or realisable assets. But it is a matter of commercial judgment. So again, this comes back to my point about ensuring that you can satisfy a court on an application if you are challenged. And as I say, I think you will at some point be challenged. Being able to satisfy the court that your decision was not reached in bad faith, that ought to be easy, but also not so perverse that no reasonable monitor could have reached it. I've covered extensions a little already. Exits, I know a lot of you are more interested in. Where does this actually lead you? So these are the sort of routes to extension. The first is the director extension that I mentioned earlier. You get a further 20 business days. So in reality, your application to court, if you need to make one because there's a winding up petition, or your filing of documents at court, will get you, assuming all else goes as it should, will get you 40 business days. So it will get you a couple of months, because you don't need the consent of creditors. You do obviously need the ongoing consent or support of the monitor. But the directors just certify the company remains unable to pay its debts, the same things as I covered earlier. And you can then get a director extension under Section A10. So that is the filing of document support, and that is the one where the court sealed them and listed a hearing. You don't need a hearing. It's just that's how the section operates. The creditor consent extension, as I mentioned, you can get up to 12 months from the outset. You need the approval of pre-moratorium creditors, but there's no court involvement. If consent is obtained, you just file the documents at court again. The things that I tend to be involved in, of course, by their nature, are the court applications at Section A13. That's beyond 12 months on creditor consent, or it's very unlikely to happen in practice, certainly not very commonly, wherever consent isn't available. Although the court does, on a Section A13 application, have to consider the interests of the unsecured creditors, the pre-moratorium creditors. I described this to a judge recently as requiring the court to consider their interests, not their views. I think that's right. That's what the legislation says. Obviously, their views will be persuasive in the right case. But if they are just doing it to be awkward, doing it to be difficult, doing it because they don't know what a moratorium is, doing it because they say they don't want to give the company any more time, if the test is met, I don't think, and this hasn't been tested to my knowledge yet, certainly not in any of my cases, but I other than the HMRC one where they were objecting because of the payments they said had been missed. We'll see if my other one ends up in resulting in substantive objection from HMRC when it comes back in September. But that's the test the court will apply at that juncture. And I think that's probably quite similar to the monitor having certified that it remains likely to be rescued as a going concern. Because of course, if that's the case, the debtors will be paid in, the creditors will be paid in full. So that must be in their interests, is my view of that. As I say, requires a court application, requires an updated statement from the monitor, and that's every stage. And I think you're probably starting to see, for those of you not familiar with the way these work, the importance of the monitor's role and the centrality of the monitor's role in these applications. Where do they go? I was asked this by an IP at a lunch talk I gave recently, and the answer is sort of anywhere. Obviously, the aim is a full recovery or a full refinancing, pursuant to which the debts can be paid in full. At that juncture, the moratorium ends, company exits, company keeps trading. And that's the sort of paradigm situation that I think Part A1 was probably intended to facilitate. Because the directors have remained in possession throughout, then it's a means of facilitating the company being rescued straightforwardly and continuing to trade. CVAs are another possibility, schemes of arrangement, RPs, admins, or liquidation. I have done one where they've gone into CVL. That was one of the energy scheme ones, and the company, very sadly, the energy companies seem to be sort of structuring these arrangements such that they put so much pressure on cash flow. The company can do so little about it. So in our one, we were saying to the court, please extend for 4 months to either allow us to pursue dispute resolution with the energy company or to issue proceedings against them. And then you can take a view, Judge, at that juncture in 4 months' time, once we've issued a claim, as to whether they've defended and if you should give us time to allow that to unfold. So I think they might even be useful in really long-term scenarios like that in the right case. In that case, unfortunately, because the energy company slow played it so much, their dispute resolution mechanism under their contract was such that you had to go through 3 different levels of different kinds of dispute resolution meeting before you could even arrange a mediation, and then before obviously you could then go down the litigation route. They then held on to further, there were further retentions out of further POs, which meant that the cash flow was so severely impacted that they weren't able to keep trading and to pay their post-moratorium debts. And so I believe, and I saw correspondence from the monitors saying that they needed to terminate. The director, sadly, and with a very heavy heart, I think, agreed, and the company went into CVL probably the same day. So that's one of the other possibilities. I think if given his time again, he would probably do the same thing. I think he believed that he could find a way out of it, as a position many of us will be familiar with, having dealt with directors of distressed companies. But genuinely in that situation, it was a third party who really effectively controlled that company's cash flow. I've put a slide here on the super priority waterfall for the IPs in the room in particular, because you will care about this, I think. The provisions of Part A1 and the sections it's inserted into Schedule B1 are such that if administration or indeed liquidation begin within 12 weeks of the moratorium ending, unpaid moratorium debts are priority pre-moratorium debts, and they then rank ahead of even the monitor's remuneration and expenses. So I've set out the sort of waterfall here that's called the super priority waterfall. This was the recent authority, the recross case that was a couple of weeks ago. It's quite, if you have this specific scenario in prospect, then it's worth a read. Otherwise, I think it's a bit niche to be useful generally on moratorium cases. But this is what the court held the effect of the super priority waterfall is under section 60, paragraph 64, capital A. So the goods or services supplied during the moratorium are first, then wages and salaries, then other debts and liabilities, and then last, the monitor's own remuneration and expenses. And this is that decision, if anyone is interested. It was a decision of ICC Judge Jones sitting in retirement from a couple of weeks ago. And there's the reference to para 64A, the must obligation to pay the protected moratorium debts confers upon the protected moratorium creditors what's called a super priority, as it's described in the text. So some pitfalls and some practical lessons. I'll finish off with where it goes wrong in practice, where I've seen it go wrong in practice, and therefore the things that I think directors and advisors need to be aware of. And I know that I'm speaking to two sort of slightly distinct categories, but one of the things I should say at the outset, much as it is a bit twee, it's really helpful to have a good team working on these, because you will need the monitors to be working on the financials and on their certification that the company is likely to be rescued as going concern. You will need the solicitor level conversations to be going on with the directors to stress test viability at a really early stage, and quite a close awareness of the nature of their business and the nature of the exit route, and the reason that they say a monitor is going to be able to conclude that the company is capable of rescue as a going concern, and is likely, not just capable. As an IP I was working with, and one emphasised recently, it is not just capable, which is absolutely right. Lots of companies, or almost all companies, are capable of being rescued as going concern. If the director wins the lottery, then they are capable. It's not that, it's likely, and it's likely on a balance of probabilities. So it's a relatively high threshold. And then, of course, I would say this, but counsel being involved at a relatively early stage to advise on the technical requirements, on the mechanisms, on all the documents. They are quite technically dense in terms of the various statements that have to be made. There are rules inserted into the insolvency rules by Part A1 about, for instance, the time within which the statements under A6 have to be made. So it's within 5 days of the application being made. So again, there are lots of little technical traps to be aware of, and I think a really good division of labour at an early stage is really important for getting these applications over the line. I should say that all of this makes it sound like a really long-term process. I have done a couple where we, from the inception of the idea of a Part A1 moratorium through to getting the order was 2 or 3 days. So they can be done really, really quickly if you've got a whole team of people who are working very intensively and working very late in the evening. I think ordinarily you should expect them to take a week or so, but it is possible to get them over the line really, really fast if you need to. So they are quite agile. And of course, again, my excellent clerks, but I'm sure clerks generally are in touch with the listings teams and able to arrange my clerks seem to work miracles, but are able to arrange very swift hearings of these applications in the ICC interim applications list. And as a matter of practical advice, these are suitable always, I think, for a hearing in the ICC interim apps list. They're obviously urgent, so that's one criterion. But also, I think they are, because they haven't been challenged very much yet, they're not that lengthy in terms of taking the court through everything. You can definitely get yourself in under that 2-hour threshold for the Insolvency and Companies Court's interim applications list, which now runs most days. So pitfalls for directors, I think first and foremost is waiting too long. I think where these are massively, and this is not in my interest to say this because it doesn't involve me, but the best version of a moratorium is the one where you do an out-of-court filing, because you don't have the expense of counsel and of solicitors preparing applications and so on and so forth, and of evidence needing to be prepared, and of a detailed report. You need the sign-off from the monitors, their statement, and the director's statements in standard form, and it can be filed out of court. So I have seen a couple where they have left it probably a week too long to get to the realisation that they were going to have to do something, and HMRC has filed a petition. Part of my pitfalls warnings is that HMRC, as lots of you, most of you will know, are so much more aggressive now than they were in terms of presentation of a petition. And I am increasingly finding, I think I have done 3 of these where what we were saying to the court on the evidence was, we were discussing a time to pay arrangement with HMRC. We'd sent them our proposals. When we chased them, they told us they were considering them. And then out of nowhere, we got a call from one of these firms saying, do you know there's a winding up petition against you? So they are quite, it is important to get on with it as soon as you start to see the writing on the wall, and as soon as HMRC starts to be difficult, I think. Don't treat the moratorium as the plan. I have advised on one of these, in fact, drafted all of the documents, got the skeleton ready. We were absolutely ready to go, and the monitors I was working with were working day and night to oversee the company's financial position. It's a company in dire straits in terms of cash flow, extraordinary levels of lending. And I think they were viewing this as the way out. It comes back to looking at viability at an early and at the earliest possible stage. It is not the plan in and of itself. It is a really, and can be a really useful tool in my view, as what I've called a bridge to the rescue, but it is not the destination. It's not the rescue itself. And the court and the monitor both need to see that as credible. And on that particular case, even when I'd gone as an alternative route to go and get a validation order from the court, the judge said to me, yeah, but who's going to buy this company? And that's really where the court's mind will come down to. I thought that was a good insight into what the judge is looking at. And that would have been the same question if our application had not been for a validation order, but had instead been for a moratorium. Underestimating the debts. This comes back to my case, I think, on where the cash flow pressures became too much for the director and for the company. Of course, new liabilities incurred have got to be paid in full as they fall due. So the court will want to see that your cash flow forecasts include that. That will include HMRC liabilities. And of course, those are the largest, typically the largest ongoing liabilities. The other thing to think very carefully about is to make sure that this is actually achieving what you think it is in terms of rescue, because some agreements, not all finance documents I've seen do include a moratorium, and some of them expressly say that a moratorium is not an insolvency process to trigger whatever termination possibilities there are in and provisions there are in contracts, but make sure that a moratorium isn't a default or a termination event. In practice, often they're not terminating anyway, but if it's the kind of case where you need to worry about that, then make sure you are worrying about that. Pitfalls for advisors and monitors, being very clear about who this gives you protection from and who it doesn't, and advising accordingly. Make sure you're checking the exposure rather than relying on a moratorium to hold back, in particular, secured lenders, but any financial, a lender under any financial instruments. Under preparing the court application, as I say, the one that I did, the only one I've done that's been dismissed of the 10 or so that I've done now, the monitors hadn't prepared a report. And I think the court was quite surprised by that. I know the court was quite surprised by that. They are placing a huge amount of reliance on advisors generally, but in particular on the monitors. And the reports I have seen, the good ones, have been extremely detailed. And the reason for that is that it's a fairly summary process, the court looking at it and saying, should I reach the conclusions that Judge Greenwood tells us in the Grove Independent School case need to be reached? And they are really relying on the monitors having done the hard yards, having put in the legwork and reached the conclusion as a licensed IP and as somebody that the court can rely upon to found its own conclusions about whether it should make an order. I think, as I say, I haven't seen any of these in practice yet, but I do think it would be wise to continue to document the basis upon which you are constantly concluding that this company remains likely to be rescued as a going concern. I think that's probably the best protection. The Diamond case tells us that it's probably the best protection against later challenge. I know that's quite a difficult thing to do because you are under a lot of pressure from the directors, I suspect, who you're working with, who are paying your bills, who are desperate in lots of cases to find a way out. And as I said earlier, in relation to missed payments, I don't think you have to be completely draconian about it. And I don't think a court would expect you to be. That's my sort of sense of it from how I'm seeing the courts treating these in practice. But I do think you need to be quite careful about keeping records of the basis on which your decisions have been reached, because there will be they're quite a substantial interference with creditors' rights, and I think we will see cases soon where creditors are starting to challenge, and I think foremost among them in the very near future, probably on two, I think, of the ones I'm doing at the moment, that will be HMRC. And then finally, just that point further to that decision of a couple of weeks ago, the Cross case. Don't overlook the risk of your own fees. Think about protecting yourself. Think about ensuring, from our side, I know that we ask for money up front on these where work's to be done. Many of you will be familiar with that approach. I think it's a very sensible approach, but as the monitor, be careful and make sure you're protecting yourself, and don't assume that you're going to be in a super priority position yourself. You will rank behind various other categories of payment. Typically, that won't matter because there will be enough money involved that will be paid anyway, but just something to be aware of in view of the recent decision. So I see that with 3 minutes to go, there's just some time for what I would like you to take away as your key takeaways from a bit of a whistle-stop tour through a relatively detailed and complex jurisdiction, but I hope it's been helpful in summarising these, giving you a bit of a flavour for how they work and where you're likely to advise that they'll be useful in practice. I think it's no longer a novelty. Certainly my experience, and even having done 8 in the last month, and there having been 8 in the last month, shows us that I hadn't done 8 in the preceding 6 years. So we are starting to see them used. I have suggested them in a couple of cases and they have worked. So there will be a place for you to advise that they are worth consideration and worth being pursued. Still relatively niche. I think in particular, the fact that you have to have that bit of a fighting fund, you're going to have to fund the monitors in reading in, assessing the company, preparing their report. You're going to have to fund your solicitors in advising you, and you're going to have to fund counsel if it's a court application. If they're director-led and director instigated and extended, they're much cheaper. And I think probably will become much less niche as people start to become familiar with them. It doesn't buy you a rescue. It is not the destination. It is a bridge to the destination, but it does buy you time and it buys you a relatively substantial period. We will all have come across directors who, if you could have said to them, it will cost you X thousand pounds, X tens of £1,000s to apply to court, to get an order and to get an extension by you as the directors, they'd have snapped your hand off. So it does buy you some genuine time. I think financial creditors are the main blind spots. So just sort of mapping out that exposure, ascertaining where the company's risks are in that regard and where its pressure points are in terms of its kind of position as that entry into the moratorium, but more importantly, its ability to meet its ongoing liabilities and in particular, finance lenders, finance creditors as the moratorium progresses. Again, the monitor's ongoing judgment is sort of where I think most of the real risk sits in terms of losing the control of these on a director's part. If you have got monitors who just are not going to be able to conclude this is likely of rescue kind of beyond the way a monitor put it to me when on the one where they weren't ultimately able to conclude the company was likely to be rescued as a going concern. He said from a reputational perspective, he doesn't want to say to the court, on week 1, day 1, this company is likely to be rescued as a going concern, only a week later for the whole thing to fall apart. Because to his mind, then the court is questioning the safety of his conclusions when another one of these applications come before the court. And I think that's a very wise approach to take. Extensions are available and they can be really lengthy. I mean, I think in the right case, you could comfortably exceed 12 months. And I think that makes them extremely useful in the right situations, but each route carries the conditions and the evidence and the evidential thresholds that I've run through today. Act early. I think this is probably the key one. As I say, it's taking bread out of my own mouth. If you can avoid needing to use us, if you can avoid that part of the process, they are at their most cost effective at that juncture. And then, of course, we come in and seek extensions in due course if need be. So there's place for everybody in this process. But I think many of the advantages of the process as a whole depend on getting in before a petition is presented. That is not to say they're not useful afterwards. And I have seen very many cases now where they are extremely useful afterwards. But I do think that the primary advantage comes at the pre-petition stage. That's everything I wanted to say. I see we're at 12 o'clock. So I won't ask if there are any questions because I know you will all have busy days to carry on with. Please do get in touch with us if we can help you on any of these. I hope that has been useful. Thank you very much for joining, and I look forward to seeing and hearing from many of you soon.